Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held before the State of New York, will now draw near to the defendant and will be heard.
Hui against East Broadway Mall Incorporated.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Morton Minsley on behalf of the appellant Han Fui Hoi, and on my own behalf, on behalf of fellow counsel Winnie Mock, and on behalf of our client, we wish to thank the Court for taking our case and for devoting what I'm sure are its precious resources to the issues at stake between the parties. Your Honors, this case is truly a case where all the interested parties were before the lower court, and the actions were dismissed on a technicality by the lower court, elevating form over substance. In this case, there was a timely action filed, and I refer to the record where...
By form over substance, Mr. Minsley, are you referring to the corporate form?
Yes, Your Honor. In the sense that, as was stated in the 1959 case of the Court of Appeals, the Ehrlich case that we cited in our brief, that in this case, like in the Ehrlich case, for all practical purposes, the corporation was the shareholder and the shareholder was the corporation.
And yet it is a legal entity that has, the form has great legal significance, does it not?
Absolutely, Your Honor. But in this situation, where you had a corporation that was dissolved and the right of action would have gone along with any other assets to the sole shareholder, you had the shareholder who commenced the action in a timely fashion.
When was the corporation dissolved? Was that September 94?
Yes, the corporation was...
By proclamation?
The corporation was dissolved on September 28th, 1994, as reflected by page 137 of the record.
And yet something was left over by way of corporate business, was it not?
Well, it was, and that was only discovered later after the motion practice in the lower court.
Is that the workers' comp claim? Is
Yes.
that all that was left, the winding up the business of the corporation?
Yes, my understanding, based on review of the record, there was no other claim, no other issue that was left open, and that was only brought to appellant's attention by respondent in its papers in opposition, in support of the motion to dismiss in the lower court.
The judgment was filed in January of 96.
Well, my client was not aware of it. Apparently, there was
He
no.
had left. He had gone. He was in Hong Kong at the time.
I believe so. And it was very small. It was a very small judgment, and there's no doubt.
$4,232.58.
Well, relatively speaking, given the fact that you're talking about a construction company that had at least one contract here for $4 million, that could easily have been taken care of. And the bottom line is that at the time the action was commenced, it would have been easy for the plaintiff or the appellant before Your Honors to have made the choice to bring the action in the name of the corporation. He had the authority to do it one way or the other. It's not like the GMAC case that was relied on by the appellate division, where there had been an assignment for the benefit of the creditors and the shareholders had lost control of the corporation.
If that was so, why did he, several months after, well, a year and a half after he brought the action, why did he then assign cause of action to himself?
Well, that was done apparently as an attempt to remedy the defect, the argument that was made by the respondents or the defendants in the lower court. When the respondent made the motion to dismiss and argued that the action should have been brought in the name of the corporation, the assignment was made to an attempt to cure that defect, to make the individual shareholder stand in the same shoes as the corporation and have the authority both as an individual and as the corporate entity. So at the time of the assignment then, the individual shareholder, Mr. Hoy, had stepped into the shoes of the corporation and attained whatever rights the corporation had. And one of those rights would have been to intervene in the pending action, which I want to emphasize, I'm sure your honors are aware, was commenced timely because of the acknowledgement of the debt by the corporation in 1994.
Mr. Minsley, were you to prevail, what would be the rule that would emerge?
If I think the rule that would emerge is the rule that was adopted by the Schleit versus Stamler case, that in the event that a situation like this comes up again, that where you have a dissolved corporation and you have the action brought either in the name of the corporation when it should have been in the name of the individual, or the name of the individual when it should be in the corporation, and everyone is in front of the court. The remedy of the court should be to bring to where the parties are right there, to add the proper party to.
And to have the claim relate back to the date of the original filing?
Yes, Your Honor. Yes, Your Honor.
The case that you cited was decided based on a statute, CPLR 1003.
Correct.
Under its previous wording, which gave the court some authority. Under the current wording of the statute, there has to be leave of court.
Well, I think.
Does that make a difference? That we're dealing with a different statute now?
No, I don't think so. I don't think so, Your Honor. I think that the court has the power to grant that leave of court, and should, in the Schleit case, where the appellate division sua sponte granted it without ever being requested, without the relief ever being requested in the lower court, I think the same power should exist today.
But
I'm sorry.
do you really need it here? Because you had the assignment, so technically maybe the corporation didn't need to intervene. It had already assigned its client.
I would agree. One way or the other, you either have the individual who stepped into the shoes of the corporation to be able to prosecute this case, or if the form is important, as Your Honor cites or states, then you could bring in the corporation and have all the parties before the court and proceed with the action on the merit, where basically you have a simple action to collect the construction debt, which is very much like the early case where the shareholders were granted the right to pursue an arbitration clause and pursue an action in arbitration, even though it was a different corporate entity that was pursuing the claim than the corporate entity that originally had entered into the contract. So the idea is that you have all the parties before the court. I think Your Honors clearly understand the record, and I think that in order to this case be decided on the merits, that the dismissal of this case should be reversed. It should be remanded to the lower court for further proceedings. And I just want to emphasize that the action was commenced by Mr. Hoy in good faith. He had the option at the beginning to choose which form to prosecute the action. He in good faith believed that the corporation had been dissolved, that there were no claims against the corporation, and this was the proper way to proceed. And when it came about, it was pointed out by the respondent that this was not the case. He attempted to remedy the situation by the means of the assignment, and like Your Honor says, you could either proceed on the basis of having the corporation pursue the action or the individual pursue the action, or both. Thank you, Your Honor.
Thank you, Mr. Minsley. Mr. Santos?
Good afternoon.
Good afternoon.
It please the